All right, all right, all right. Got a little feedback going on there. All right, appreciate you guys tuning in on Family Law Fridays. We back at it again. Give ourselves a round of applause for making it to the end of the week. Well, almost the end of the week, right? TGIF. Hope you guys had a good and prosperous week. Um, Welcome to Living Equity Podcast, where we are fishers of men and women. This is for entertainment and educational purposes only. If you are in need of legal advice, I do advise that you seek yourself a competent attorney. Uh, I am not a lawyer, and this is not a law firm. I think we got that out the way. It's the proper disclosure. But yeah, welcome back, man. It is Family Law Fridays, right? We about to drop a bomb today, you guys. We're gonna drop a bomb today. Big bombs, big bombs, big bombs, big bombs. Gonna light it up. Now, today's episode, we're gonna talk about parental rights or parental power, right? And parental power is actually a property right, which stems from or is founded in the natural law. Okay, and when we talk about property rights, we're talking about to the labor that provides or that results in proceeds from that child and the services of the child. You, as a parent, mother, or father, have the right to the labor and services of the child. And the labor and services of the child is a property right. And once you have been, or that right of, as a natural mother or father has been fully terminated, um, you no longer have the right to the labor and services to the child. So once DSS or whatever department that runs the Title 4D or Title 4A program in your state, once they make you a non-custodial parent, which devolves you from a mother and father to a visitor, right? And this devolving of title was with no fault of your own. You have been stripped of the right to the labor and services of your minor child. The labor and services, you might think like, oh, I'm a slave to child or something. Well, back in the day, it was proper to upkeep the estate, and the estate was typically the lands or the lands of the castle home, right, of your mother and your father, and your name, of course, the name of your mother and father, which I talked about in the last episode. Um, but the name actually answered everything. Your name was a representation of the description of land, and you, as a child or an heir to that state or heiress, you are or were to inherit that estate. But while you were here on the earth, you were to, maintain it so it could be properly passed down to you. So in today's time, we might be talking about cutting the grass, taking the trash out, washing the dishes, those things that entail managing and upkeeping the estate. Now, in days time, when your children go out and get a job, I mean that's still the same. You have the right to the labor and services of your child while they're in their state of minority. Um, of course, when they reach the age of majority, that is on a different footing. Uh, but yeah, this is the episode. It's going to be talking about this book here, Treatise of Rose. And whoever wrote this book is just absolutely heaven sent, man. This is some good information in here. I remember my first time reading this thing a while ago. I was just like, wow, you know, the blatant how they just hide information from us purposely, right? They leave you just for a interest to, uh, extort you. They all have a pecuniary interest in these court cases, every last one of them. If you don't think so, I don't want to call you a fool, but I definitely kind of want to, but I'm not here to insult you. I want you to be informed that they have a pecuniary interest and they are extorting fathers and mothers. They are alienating the children. They are abusing the child actually, and they are running uh, a children trafficking ring, but a so-called legal one, and we can challenge that too because Title 42 that actually houses the Title 4D program, which is the child support enforcement. And I don't like to use the word child support because case law has already determined that it's not in the best interest of the child. So technically, it cannot be child support, where in fact it's to benefit the state treasury, or better words, the taxpayer, right? Um, excuse me. So, if you have a Title 4D program, if you're subject to the Title 4D program, this will be a good eye opener for you, a good substance, maybe something that you maybe be able to put in your arsenal and definitely study up on. Read these case laws, you guys. Case law, case law, case law. Read the case laws. Very important to read these case laws, because it's kind of your ticket to a higher court. You know, if a judge in the lower court makes a decision and makes the wrong decision based on law, it can get taken to a higher court because they made an error of law versus a fact. But yeah, let's get into it. The treaties of Rhodes. Get into this here. Excuse me. One moment here. All right. Boom. All right, now let's get into it, you guys. Got a little technical difficulties here, looks like, but I think I got it going. I think I got it going. I think we're good. I think we're good to go. All right, treaties and roads. Disclaimer: not for any court use, for educational and entertainment purposes only. I totally agree with that message. All right, chapter one: a non-casting of children upon the public and the nationwide police state. The Child Support Establishment and Enforcement Scheme. Title 4D, a congressional legislation arising out of the Federal Social Security Act of 1975, which requires every state to manage and administer a child support enforcement program as a condition to receiving federal funding. I think that's Title 42 of 654A, where the federal program actually requires the state to come up with a plan on how they are going to administer the child support program in their state. And that program has to be approved by the federal government. So when they make it try to seem like child support is a state issue, no, it's actually a federal issue, right? The federal and the state government enters into a contract, a cooperative agreement, for better words, and the state agrees to get reimbursed 66% on every dollar and be able to participate in a pool of funds or a incentive based on their performance. They get this pool of incentives that they be able to participate in and get additional funds. Uh, so that's a little bit of background how the state and federal government work in a form of a partnership when it comes to child support enforcement. Let's see. It says Congress legislated the Title 4D in the federal interest of the general welfare to ensure that the states were pursuing absent parents who were casting their child upon the public in order to reduce dependency on welfare. So the program was created to minimize uh, those individuals who were forced or at risk on being on welfare because they were cast to the public and be left fend for themselves. So we already get a hint already that one way that someone gets qualified for a Title IV-A uh, 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 welfare is upon being at risk of abandonment or being abandoned or some form of their parents being absent, right? Let's keep going. In other words, American taxpayers uh, were now footing the bill of an increasing amount of recipients on welfare because of absent parents who were failing to provide adequate and necessary support to their children, thus casting the child upon the taxpayers to take care of their parental responsibilities. As such, Title 4D was created in response requiring all 50 states to manage a child support program to pursue absent parents as a condition to receiving federal funding in order to reduce a family's dependency on welfare. It also created it was also created to help families avoid becoming dependent on the state because of the lack of support from an absent parent. So, bingo, we have an identifier. What is our identifier, ladies and gentlemen? A absent parent. I repeat, an absent parent. And say non-custodial parent. Well, how do you become a non-custodial parent? By first being an absent parent. And I would dare, as I stated before, and I'll state again, no evidentiary hearing was ever had to prove that you were in fact absent. I challenge you. Matter of fact, I challenge you. Find me a definition of absent parent in the Social Security Act or in your state statute or anywhere besides case law. If you can provide that for me, and this is not a ego challenge. This is really like, please, if you can find that definition somewhere in law of an absent parent, please provide that. I can't find it. I found some case law on it. Now they don't call it an absent parent; they call it parent absence. But I mean, even if it's reversed, you're saying the same thing, right? Tomato, tomato. Then it says, it was also created to help families avoid becoming dependent on the state because of the lack of support from an absent parent. Based on the intent of Congress, legislation of Title 4D, it is a fact that the only individuals who may be forced to pay support under state or federal police power are absent parents. Now, they keep saying state and federal police power, of course. The enforcement of child support is a police power, which we like to call the 10th Amendment, where the state gets to actually enforce it. It doesn't need the federal government truly to be involved in regarding the enforcement and the laws that it puts in place to enforce it. But again, as I stated, federal government requires that they come up with a plan, and the plan consists of the laws that they will create to ensure that the Title 4D program will be enforced. And this program, by the way, is voluntary. It's not mandatory. Voluntary on the state. So if it's voluntary for the state to accept and actually be a participant in the program, why can't it be voluntarily for you? Now, before I continue further, please, ladies and gentlemen, no, I am not in no way, shape, or form telling you not to take care of your child, of your offspring, better yet. I'm not telling you to do that. I am not telling you to do that. Matter of fact, if you are a deadbeat, this is not for you. You don't need to be listening to me. You need to turn the channel, go to another daggone page or something. If you are a deadbeat, you need to take care of your child. Actually, this law was meant just for you. For you. This is for the individuals right here. This video it's all for the individuals who uh, are taking care of their children, doing the best that they can for their child, but seem to be, have the cards stacked against them. Maybe the relationship between the mother and father is not working out. Retaliation is going on. Unfairness, unjust. Maybe you don't have the financial ability to hire an attorney and do whatever you needed to do for you. Whatever. Maybe you don't have the time to study the stuff on your own. So you need a little bit someone like me who maybe have 10, 12 years in the game who can give you this information in 10 minutes. You're welcome. For those who are really taking care of it, this is for you right here. Now, if you're not, you deserve what's coming to you. Honestly. Honestly do. Um, and it says, the I think we can keep going. That's kind of so. It says, so what, and who is an absent parent? Are non-absent parents being forced to do what they have not failed to do as absent parents? Well, what is an absent parent? Arguably, one of the most important congressional legislations in history, strangely, did not define the subject and target of its legislation. So they're saying there's no legislation or anything, law that will actually define actually who the law or the legislation that was created to target. It was created to target absent parents. But however, there's no definition of this word. There's no definition of who is defined as an absent parent. Now, you're going to find out what it is through many ways besides in legislative act, maybe again through case law. It says even more strangely, there is no court or 4D agency in the United States that has nor issues any hearings to determine whether any parent is absent or was made absent through no fault of their own. So again, there's no evidentiary hearing, which is a due process issue that actually shows that, hey, you know, I'm only absent due to the fault of the mother, meaning the mother took the child and carried away the child and decided to take care of the child of their own, without even consulting with me about it. That's why I'm here. There's no hearing on it. Is this everything is hearsay and presumption that you are not taking care of your child, mainly fathers. And they devolved your title from a father to a non-custodial parent, really by taking your parental rights away from you, taking your parental rights where they're essentially taking your property rights away, which is a protected right. Now you might be like, well, kids are not property. They're human beings. They're flesh. They're spirits, so on and so forth. Well, doesn't that semen that goes into an egg that becomes a fetus that lives to be a human being, child, man, woman, whatever? It was first in my body or in your body as a male, and in her body as a female, and you guys come together and boom, create life. Is not your semen your property. It's not your egg your property. It's not your body parts, your wombs, everything. Roe versus Wade is my body, right? How are you going to tell me to do with my body? Well, how can you tell me what to do with my job unless I am not providing the necessities or the necessaries the child, or I'm abusive, right? Or I again abandon my child, or I give my child up to the public, then I can see how it it applies to me. But how could it? Okay. Although there is no congressional, even state definition of an absent parent in the U.S., the United States Supreme Court has defined what would be parent's absence in providing support to a child in the case of Carlson, in their stating the nature of the absent is such as either to interrupt or to terminate the parent's functioning as a provider of maintenance and support, physical care, or guidance for the child, and the known or indefinite duration of the absence precludes counting on the parent's support or care. According to the U.S. Supreme Court's definition of parent's absence, the definition of an absent parent then could fairly be stated as one who interrupts or terminates his or her functioning as a provider of maintenance. Well, I don't think maybe 90% of us do not terminate our or interrupt, our function as fathers or mothers. It's interrupted with no fault of our own most of the time, right? The relationship ain't going good. You're going right down to the court, put you right on the papers. And I mean, who are we to challenge it, right? It's for the support of the child. How dare you not want to pay child support? I mean, why do we need the state to interfere in our dealings? We had them in private, we raised them in private, right? Why do I need the state to tell me how to raise my child? Matter of fact, why do you need why do I need you to assign your right to the state to come after me for something that I could do on my own? Is it maybe because I'm not doing what you want me to do when you want me to do it, or the amount you want me to do? Or matter of fact, if that's the problem, let's go 50-50. Split. Let's split this thing down the middle, 50-50. Bet you wouldn't do that though. If it's really about the child, you would go 50-50. It's mainly about control. You want to be the king and you want to have a peasant to pay you a tax, monthly tax. All right, I'm going on a little tangent. Um, the natural law in speaking on a parent's support of a child has been clear in more than several dozen jurisdictions and is the most important source to the answer of our first question. What is an absent parent? This is because the natural law proves that there are two distinct acts that must occur before parents can ever be absent parents. A parent, one, must refuse to take custody of the child, and two, refuse to render them a proper support. So those are the first two things natural law requires before you actually can be deemed or considered an absent parent in the eyes of the natural law, in which most of us get our children from. Is That's a realm of natural law. That was a gift to you from God or your creator, right? Or whatever you believe in. That was a gift of life. Right. Let's keep going. Uh, these two distinct acts fit within the description of the U.S. Supreme Court definition of a parent's absence. In the case of Carlson, providing substantial legal weight and our sources arising from the natural law. Furthermore, because the case speaking on the natural law touches more so on common law existing in the laws of nature, pre-existing government, its cites provides powerful legal authority for all jurisdictions. By the way, you should know, but common law is how you got all these statutes and codes. Without common law, there will be no statutes and codes. And I'm not saying that it's common law fault. No, I'm not. That's not what I'm saying. It's not what I'm saying. I just do a civics. Learn law, and once you learn law, you understand that a lot of common law was creations. I mean, a lot of the statutes and codes was a creation of or a spin from the common law to inflict punishment. Because typically, if you rob me, I'll go rob you back. So to prevent that, you know, because we knew not to rob your neighbor, that was something that I didn't really have to tell you. But because if it does happen, we do have freedom and free will. Doesn't mean that your freedom or exercise to that freedom to do what you want should impede or infringe upon my right of happiness. So if your right starts to impede with my right, then it's not really a right that you have. So, in order to create a little bit more order with society, they created these statutes and codes to maybe inflict or create punishment for you robbing me, and then creating that punishment so I won't have to go rob you back. So it's a little bit of small little inkle, little history on some common law there, laws a little bit. Let's keep going. It says, as a starting point, we arrive at the 1889 Indiana Supreme Court case of Ramsey speaking on the natural law and the two distinct acts of a parent that would fit the definition of an absent parent in its stating the father has, in some way, manifested his purpose to abandon their child or has refused to take them into his custody and render them a proper support. Now, for those who might be looking at 1889, there's 2025. If that's the case, if you're the type to argue age or year of a document or case law, how old it is, then you might as well get rid of your your Constitution and a lot of other documents that are pretty old. If you're going to say, well, it doesn't hold weight because the age of it, and I'll also, and on top of that, there's no, I'm sure there's no other case law that actually reversed that. I'm pretty sure of it because there's other states, sister states, that actually um, state the same thing, have rulings on the same thing. It says Here, well, I read that part. Here we have two distinct acts, as previously stated, describing an absent parent as it exists in natural law. To wit, one, a parent refuses to take the child into their custody, and two, refuses to render them a proper support. I can guarantee you, most mothers, fathers, just they're doing what they're supposed to do and end up still being on child support. The Indiana Supreme Court case of Ramsey further describes these two acts and a fact situation that surprisingly applies to millions of fathers across this country currently. Ramsey stated that when a man abandons his child and casts it upon the public, that's the abandonment of the child right there. That's the casting them to the public to for the state to take care of them or giving them up for adoption. He becomes liable for support. So that's one way how you become liable for the child support or the child's support is if you abandon the child to the public. But it is entirely impossible to treat a child as thus cast upon the public, whom when the fact simply is that the mother has deserted the father, wow, and carried away the child and continues to support it. So it's basically saying that, you know, despite those ways we can determine absence of a parent, most of the time, that's not the case. The case is that the mother has taken away the child and decided to take care of the child on her own without knowledge of the parent, the father or mother, of course, but mainly father, and consent of the father. Typically holding them hostage, and he has to go down to the court to get visitation rights, right? He has to do all these things, and by him doing that, it comes to child support. Even by trying to go get rights, child support loves to follow it, be in the shadows right behind you, like, hey, yeah, you want visitation rights? We can get that to you, but we're gonna be hollering at you about the child support. Just hold tight. Uh, what Ramsey proves is that no father can be an absent parent if the mother has deserted the father and carried the child away. In this instance, a parent has not refused to take custody of his child and rendered them a support according to the two distinct acts that must occur according to natural law to be a parent. Rather, the parent's functioning of a provider of support and maintenance has been interrupted through no fault of their own, according to Carlson's definition of a parent's absence. According to the reading of Ramsey, and it's speaking on the natural law of a parent's support of a child, a man cannot cast his child upon the public through acts that were no fault of his own, and thus it only follows he cannot be an absent parent, excuse me, within the meaning of the Title 4D. Today, Ramsey proves so much more than merely describing one who cannot be treated as a parent who cast their child upon the public. It proves that possibly millions of fathers across the country are currently being forced to pay support under Title 4D, although they were made absent through no fault of their own, but fault of their mothers, of the child's mothers that kept them away from their children. Even mothers have been made absent parents by acts of their child's father in certain circumstances. Shockingly, what the natural law proves is that any parent who has kept the child away from the other parent for no legitimate purpose has been awarded for doing so in the form of monthly child support payments coerced under the state police power through contempt proceedings. Wow, that is very, very true and very powerful. Very, very powerful. The mother is being awarded something called child support just to keep the child for alienating the child away, keeping the child away from you and alienating the child. He gets awarded for that. That is so true. That is so true. This explosive news under state police power through contempt. Excuse me, I'm all over the place. This explosive news and will send shockwaves and threaten a very lucrative family law industry to its core. What this means is that possibly millions of parents have had their assets, income, and property all awarded to the other parent for that parents engaging in the acts that many doctors and psychologists today called parental alienation of a child. Wow, that is powerful right there. Very, very powerful. That is exactly what they're doing. It's parental alienation. It's really child abuse, and the other parent gets awarded for alienating the child. That is, like you said, most doctors and psychologists will call that alienation. But when it comes to child support, it's not, or family law, it's not called that, right? It's crazy. Um, you know, family law or child support is about a third or two-thirds of a state's budget. You're talking about a big corrupt mafia ring. This is why it's gonna take a lot of us to continue to fight this peace. Now, if not get rid of it, reform it. Make sure that due process requirements are given to all parties before a child support order is issued. Administrative order, because it can't be judicial. Child support is administrative. They contract with the courts to use the court space and services, and these judges get paid. They're called quasi judicial or quasi judges per the federal manual of on child support. So it's not my words, ladies and gentlemen. That is straight from them. Okay. And I'm gonna read a little bit more, and then I'm gonna pause, and we're gonna do an episode 2 for next Friday. I'm gonna give you all the sauce tonight, and then keep you bored. And I know you kind of getting tired of listening to my voice. I'm tired of hearing it. uh, the 1929 Georgia Supreme Court case of Hooten goes even further into the natural law, again describing the two distinct acts that must occur before a parent can be an absent parent. However, Hooten outright states that a parent is relieved from the duty of support if deprived of the custody of one's child through no fault of their own. It literally reads as follows. The right to the custody and the earnings of his minor children are reciprocal, and that whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. Wow, that's in Georgia. that is powerful. Basically, what they're saying is the right to the services of the child. And earlier in the beginning of the show, I said the services is the labor, the proceeds from the labor that they exercise, maybe outside of your supervision, maybe at work, right? And whatever services they do around the house, that is a property right. And once they take away your custodial right, they also take away your right to the custody. Well, excuse me, they took away your custodial rights, but they also took away the right to the services and labor of the child. By taking that custody right from you, they also take the right to the services and labor of the child. So by taking that, and they're reciprocal, they're saying in Georgia Supreme Court case in 1929 that you don't really have to take care of the child once you were devolved to a non-custodial parent, or your parental rights were in a sense terminated or interrupted because of no fault of your own. Yeah. I'm gonna read one more, and these two last paragraphs, and we're gonna wrap it up. Even in the 1984 Supreme Court of New Hampshire case of oh gosh, that is an Italian name for sure. Siciliano support the notion that a parent's obligation of support is contingent on the parent actually retaining custody of the child, thus providing supporting authority for their sister's Supreme Court in Georgia in its Supreme Court case of Hooten, that a parent is relieved from the duty of support if deprived of the custody of their child through no fault of his own. The case 2 literally states, to wit, the obligation of the parent to support and educate the child is contingent upon the parent actually retaining custody of the child. The Supreme Court And Thompson again speaks on the natural law of a parent's support of a child, stating to it, the right to the services of children and the obligation to maintain them go together. Mm. Whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. Wow. Wow. I think it was a good one. I think it was a really good one. Definitely enjoyed it. I appreciate you guys for tuning in to Family Law Fridays. Definitely going to have another one coming back at you next Friday. Um, Go ahead and follow and subscribe at Living Equity on YouTube. Follow me on living.equity on Instagram, and Toure Ali, Toure space ALI on Facebook. Also, check us out at www.livingequity.org for any our services we offer. Now, we don't offer a lot of our services on the public platform because a lot of services we offer are private, and you have to qualify, number one, and before we actually divulge that kind of service or even help you with that private side of the ledgers, like what we like to call it. But all that public activity that you might need on there, it's all definitely on the website. Definitely on the website. If you are in need of a 15-minute one-time free consultation, you can also book your consultation on that website. And you'll get a one-time free consultation. I think it's like 15 minutes. Yeah. But again, I do appreciate you guys. Again, like, share, follow, subscribe, all that good stuff. Let your family know. And, we're definitely taking donations. Yes, I said it. I will take a donation. I'm not begging you. Believe it. I'm not. I take $1. I really don't care. And I just think that if, all this information I have behind me and it was on the screen here, it took a lot of time and effort to get this information, retain this information. It took years, blood, sweat, tears, hell, cold nights, no food, stuff like that. No clothes, no shoes, broke. It took a lot. It took a lot for me to get where I'm at. So for me to give you this information in 10, 15, 20 minutes that I had to retain in 10, 12, 15 years, I think it's worth a little donation. I think it's worth you guys can show me that you love me so I can continue to keep bringing you this goodness. But as always, I appreciate you guys for allowing me to your space. And till we see you again next time, I might just do a random one. Of course, it's not going to be on family law, but it'll be another random I might throw out there before what Wealthy Wednesdays. I didn't do the Wealthy Wednesdays this week or last week. You guys, I graduated. Woo woo, yeah, yeah. I did it. Yeah. I'm so messing my camera up. I did it. I did it. Yes, yes, yes. So I took a break. I took a break. So for the individuals who are watching, tuning in, and felt like, hey, I was ignoring you. I was not ignoring you. I was just getting my little mental woosah before I went back at it. You guys got to go back at it. I ain't done yet. I got a lot more to accomplish. So again, thank you for tuning in, and we'll see you on the other side or till next week. We out. Peace.